story in Chattanooga.com this morning. Bill Hollander, the county trustee, says that Airbnb, the short-term vacation rental platform with a global reach, is going to be remitting directly to the county the hotel motel tax for its 600 hosts in the county. There are dozens of groups like this, or dozens of platforms, this being the biggest one. According to Chattanooga.com, Mr. Hollander said prior to the agreement that his office had difficulty locating those renting out rooms or homes and had just 90 on the books, but there are actually many more, and the agreement will bring in much more money in the direction of $85,000 to from $85,000 to $560,000 paper dollars. Hollander says Airbnb will not divulge the names and locations of the individual hosts, but will collect from all of them. So we have an intervening party making payments, but hiding and obscuring those who are members. I think that's a very interesting prospect, and we want there to be more such activity in Chattanooga. Red Bank, which is a town that is trying to make itself the armpit of Tennessee. Red Bank has put limits on plans to put limits on Airbnb, as has Chattanooga, and we want to just express remorse that there's not more respect for individual men and women who run and own houses who are trying to capitalize on their property. The name is David Toulis. We are at 92.7. Love your neighbor and buy local. That's my argument. The number is 800-8949, 800-8949. If you have a problem you want to discuss with me or maybe another listener, just call that number, and we'd be glad to hear from you. Or maybe there's a complaint. Maybe I've gotten a fact wrong, in which case we will hear about the correction that needs to be made. David Toulis. Now, I'm thinking about a doctrine of notice, and not because I'm the man behind the Chattanooga Transportation Administrative Notice Project. That is a big legal reform project. It's ground up, local economy oriented reform, bottom up. Since we cannot have reform and bring justice top down, I'm proposing that we look at the fissure in the law and see that there is a discontinuity between policy in the state of Tennessee and the actual statute of transportation. So that is a notice project that I'm working on your behalf as your host here on the David Toulis Show and editor of Nuganomics.com, where the man who matters reads what's really happening and what really matters in Tennessee and in Chattanooga and Hamilton County. I've done a great deal of work in the past couple months touching on police, and I'm not sure if that's because more people have smartphones or because police are in a sort of a Death Star mode, which can't come too quickly. I'd suggest if we want to have sheriffs once again do their responsibility and stop delegating their authority to these corporation departments. After all, Mayor Andy Burke is head of the Corporation of Chattanooga, the municipal corporation called City of Chattanooga, and he has a department run by men and women in blue whose actors have almost total immunity. They have as much immunity as some judges have. Judges and DAs have seemingly total immunity in certain respects, meaning they can do whatever they want. They can really do anything they want to do under that doctrine, especially as it touches on district attorneys and judges. That there is a virtual total immunity in their activity under color of law. They're under color of law and in the law, if you will. But notice is something that's beyond just the David Toulis TAN's Transportation Administrative Notice, where you're getting warmed up to liberty and freedom, especially if you're an African American with trouble on your light driver's license or no driver's license at all, and yet you are on the road all the time. The larger doctrine I want to talk about in the context of Martha Dunay and Timothy Dunay, who were talking with you just a minute ago. But if you're just joining us, they are the grandchildren of Martha Al-Bishara, And you can read about what happened to Martha Friday. She was tased by the courageous officers of Josh Etheridge, the Chatsworth, Georgia City Police Department. And they're charging her because they have to do something, right? When you injure somebody, you have to charge them. There's no way you can shoot somebody or injure somebody, slap somebody around, punch someone, roll someone into hot tarmac on a hot day. You can't do things like that unless you have a reason. And the only way you can have a reason before a jury is that you charge that person with something. So most charges that we have filed against members of the public in Tennessee and Georgia are not just bogus. I know I'm thinking of Diana Watt. Diana Watt, the woman dragged from her car in a Title 55 commercial enforcement traffic stop. At least three of the charges of the 8 that she faces are just bogus. They're simply bogus. One of them was retaliation for past acts law, which clearly can't be applied in her case, and yet was stacked upon her again to intimidate and bully. Where the police serving Mayor Burke are the bully. They are the bullies, and they charge you with as many things as they think they can get away with, so that you'll recant, repent, and comply. That's why that's done. I talked with a public defender on Friday in the court of Judge Don Poole at the Hamilton County Criminal Court, judge who was having a hearing, and I said, "Well, how's the job going? And how's your work?" And he said, "Well," he told me, and I said, "Well, how many? Let me ask you, how many cases have you tried in the past? Let's say the past year." None. Well, here is an attorney who's not doing any attorney work anymore. He's just negotiating. All cases, all charges are negotiated down, and it's all pragmatic and it's all reasonable, and no one goes to trial. So that's a culture that encourages abusive charging by the DA and by the cops. They know it'll all be negotiated away, and it gives them force and threat. There's strength in force and threat, right? If you can apply force and threat to innocent members of the public with whom you have had a unfortunate encounter, then you are a man worth your paycheck. And so Martha Al-Bishara is being charged with obstructing and hindering. And the question I want to get to is in our culture here on the David Tula Show in Chattanooga and Hamilton County and Murray County, Whitfield County in North Georgia, where you, my listener, can hear me at 92.7. Why do laws have to be clear? And the answer is because a clear law gives notice. It's the whole doctrine of notice. Administrative notice from David Tulis, yes, okay, fine. But also a statute that's vague doesn't give proper notice. If a statute's unclear, like the Tennessee statute for disorderly conduct, has 5 provisions and 2 are clearly unconstitutional. They're unconstitutional because you can't possibly know how to obey the provision. It's unclear, it's vague, and so it should be thrown out. But why is it not thrown out? Because the public defender, the man I talked to, who has never tried one case, plea bargains everything. No one has to try a law. Laws are not ever tried. And he has dealt with hundreds of defendants, and everybody has pleaded. Everybody has pleaded. And so that's why we have laws that are unclear that stay on the books to harass people ahead of us, right? People who are in the future who are going to be facing these charges. And the lawyer guild, the bar, is perfectly fine. I was asking myself today, how is it that we've had this transportation statute since the 1930s when it was codified? The driver's license statute was created, the commercial driver's license statute written in 1937-38 session of the General Assembly. And how is it that no one has seen the problem of that law and the general enforcement of it? How come there's not one lawyer who has raised the question and overturned the law? Well, and I was boggled by thinking about that. Here I am. I'm not an attorney. I'm just a man. I'm just a guy who asked the wrong questions. I'm the slow man of Chattanooga, right? That's why you listen to me, because you know I'm slow. You know that I just don't get things, right? And so I'm going to have to ask the right question, the dumb question, right? The one that everybody's thinking about. dreading to actually utter, and not confident no one else will utter it. So people look to me, right? Well, David Toulis might ask the dumb question today, and let's see where that goes. And the answer to the dumb question is always stupid, right? It's a stupid, irrelevant answer. It's just it's just PR, it's just government marketing language. Doesn't really say anything. But the point is, in the end, that the question was asked and that it was not answered. That's the good part about being in the press. Well, the problem with the obstructing and hindering statute in Georgia, like the one in Tennessee. Well, the one in Tennessee is called resisting arrest, stop, frisk, and seizure. That's more or less the title of it. It's got several acts, several courageous police acts in it that are presented, and here you are resisting. Well, that statute cannot apply if there's not force used. Okay, so force has to be involved in that. In Georgia, there's no force requirement in the misdemeanor version of the law. And here's what it says, that you are guilty of a misdemeanor if you are a person who knowingly and willingly obstructs or hinders any government officer in the lawful discharge of his official duties. Okay, well, that's unconstitutionally vague. And here's why. Well, what does it mean to obstruct and hinder in the lawful discharge of his official duty? When is an officer doing his duty? Is he always doing his duty? So, okay, he's on the shift for 8 hours. So in every moment, in every second of that 8 hours, every minute, he is doing his duty. Is that right? Yes or no? Okay, yeah, is it yes? Okay, yes. All right, so he's doing his duty every minute of the day. So all right, now going back to the earlier part of the sentence, if you obstruct or hinder him, okay, so let's say that that I'm in a parking lot in a restaurant where he's gone in with his partner to have lunch, and let's say they get a phone call from the scanner, and it's on the little squawk boxes on their shoulders, and they're told, oh well, we've got an old woman with a knife at the Boy and Girls Club. Okay, so we're in the restaurant. They regret having to leave their hamburger unfinished, but they're going to do that. And there you are, my listener. You have had a seizure right there by the cash register. Okay, and you've fallen down and you're blocking the door, and you're palpating and you're crying out a little bit, and the cashier is hovering over you. So both of you together are blocking the door. Now, these officers are not unkind men, right? They're very gracious men. So they're going to have to go out the restaurant from the back way, back by the kitchen, where the cook smokes during his break and throws his butts down there in that old can, right? And his chaw, he spits his chaw out there. So they have to go out that door with the noisy screen door attached. And then they go down the alley and out to the front parking lot. Well, okay, that right there is you, my listener, who have had your seizure. You have committed a crime, right? Because you've obstructed and hindered a law enforcement. And since everything he's doing his lawful duty 8 hours a day, every minute of that day, you are guilty of a crime because you had a seizure, even though you didn't intend to, right? There's no intent to have a seizure. You did obstruct and you did hinder that man, that servant of Josh Etheridge of the Chatsworth Police Department in his duties. So you see why that law is unconstitutional. It's simply unconstitutional because it's too vague. It's there are not enough words in it. That's the problem. The law is too short, you could say. It doesn't have a clear scope. And so let's say that maybe you, my caller, can give me another example. Call me 800-8949, 800-8949, and we'll talk about this. Law has to be clear and precise. If it creates a liability or a duty, it has to be clear to whom the obligation rests or upon whom the obligation falls, right? There has to be a clear scope of the law. Scope would be, is it a foot-wide law or is it a 10-foot-wide law? Does the law cover everybody or does the law cover only a certain group? Okay, that's the foot-wide law as opposed to the 10-foot-wide law. Is it an 8-foot-wide law? Is it a 6-foot-wide law? Is it a 2-inch wide law, right? A lot of laws don't apply to you at all, my listener, at 800-8949, 800-8949. They don't apply to you because they're narrowly tailored to specific people. Let's say pilots. There are fuel regulation rules that apply to the man who brings the truck of gas, jet or engine gasoline to the airport. There are laws that affect people who lay tarmac, right? There are laws for people who make road signs. Those laws don't apply to you. There are laws that deal with people in the restaurant business. They don't apply to you either, right? There are all kinds of laws that apply to utilities, that apply to people in the communications field, to telecoms, to electric power board. Those laws, did you ever read them? Well, you don't have to, right? You don't have to read those laws because they don't apply to you. You are not in the scope of them. And so this law in Georgia that is going to be laid against Martha Al-Bishara, the Christian Syrian immigrant in the country for 22 years. Her son has been in the country for about 50 years. His name is Solomon. He's the dad of the young woman quoted in the newspaper and in the press in a story that has gone viral probably across the world, but at least across the United States, and press outlets from the Las Vegas Review and all the way to Los Angeles and other places. You can see references to this story. The tagging of a woman by 2 electrical prongs by men who dared not approach her. They had to fire these electrical bullets at her, because they were afraid that if they got close to her, that she might kill them. She's 87 years old. And it's a terrifying picture. I'm haunted when I think of this picture of this woman wearing in her arrest photograph. She's wearing her headscarf, right, as women often do from the Mideast. Terrifying thought that there she is. She's holding a kitchen knife. Yes, she's been cutting dandelion leaves because there are none in the market, and the family's crop has not been that great. So she's holding a bag. A bag. Maybe she's going to put people's heads in the bag, right? And standing there holding that knife, not obeying orders to throw it down. And so they couldn't possibly have done anything but either shoot her with a pistol, which they're courageously enough to take some risk upon themselves by using the taser, standing 15 feet away, the double prongs arcing out, charged with electricity, so damaging that many people have died from being electrocuted that way. And then she falls crumpling to the ground, sobbing. As she's sobbing, she doesn't know what has happened to her. She thinks maybe she's had a heart attack, but she's there on the ground, incomprehending as to what has happened. And the threat has been reduced. But the threat, of course, once she's conscious, the threat renews itself so badly that the courageous police officers in Chatsworth have to handcuff this woman with her arms behind her back, right? Because if they handcuffed her with her arms in her front, she might seize control of the cruiser, the SUV that was taken, that was brought there to take her to the booking area. I wonder if she was afforded an opportunity to have a magistrate. Did a magistrate review this charge? In Tennessee, you have an absolute right to a magistrate, and don't you fail to forget that. If you're charged and arrested, you demand judicial review of the executive act of Mayor Andy Berg's cop, right? Or Mayor Brent Lambert's cop here in East Ridge. You demand judicial review. And that is to say, before you're booked, don't let them book you apart from judicial approval of the whole thing. So you have a kind of a pre-trial there before the magistrate. There has to be probable cause, right? You cannot be booked and inducted into the police industrial complex without the magistrate's approval. So laws have to be clear because they give notice. And so an unclear law is unconstitutional if only someone would fight it. But how can we have a fight? How can we have an overturning of a statute that's bad if everybody plea bargains? If the state itself writes these bad laws and then has expansive prosecution, expansive policing, over enforcement, and then on the other end, the state says, well, we have to let the pressure off. Let's have a public defender's office to make everybody negotiate. And all these poor people who are ignorant and poor, they're not just poor because they've had a dealing with the police. They're ignorant and they're poor because they're impoverished. They don't have financial means. They have the PD to assist them, and the PD just helps you weigh out your options, right? That's all he's doing. And everybody plea bargains. The public defender in Hamilton County whom I met saying to me, I've not handled one case, not one case has gone to trial. How can wicked laws be overturned unless brave people like Constance Giles in Whitfield County say, I'm not lying. I'm not taking this line down. So that's what I want you, my listener, to think about. Are you going to take things lying down, or are you going to stand up? We need reform. We need major police reform to use the space, cover, and time, so that people are not beaten, shot, tased, killed, ground down, harassed unnecessarily. Right? If there's a real criminal, we'll let that be done to him. But everybody else, let there be lenity and grace. After all, we do live in a Christian era. David Tulisnik Radio.
3, 2, 1.
Chattanooga Radio. Digital FM 95.3 HD4. 92.7 FM's news now.
Stephen Foster, the Democratic congressional candidate, is going to miss Election Day. He'll be in jail. TFP reports he's been sentenced to 6 months in jail and 6 months probation. In Dalton, dash cam video revealed his drunken tirade against America, which he later